Oops, unmute. Hi, good morning, everyone. It's 28 minutes past. We'll give it a couple of minutes. I'll just do the normal thing and just kind of waffling on a little bit so that when people join, they can they know that there's someone here, they're at the right place, hopefully, and they can adjust your volume and things like that. Hi, good morning, everybody. Thank you all for joining this morning. Can I just ask you to go on mute, please, if you've just joined? Good morning, everyone. Still see we've got quite a few people joining, so we'll just give it a couple of minutes. If you can all go on mute when you join, that'd be great. There is a really good button on here that allows me to mute everybody, which I will do in a few minutes before we all get started. You don't need to have your video cameras on. Those of you who've got it, I know sometimes can affect the bandwidth and things like that, but it's entirely up to you. Okay, we've still got people joining, so we'll just give it a few minutes. Okay, it's past now. Just a couple of points. I'm going to record the webinar this morning, and then we'll make that available on the IG portal, as well as the actual presentation itself, because there's a couple of links in the presentation. So I'll make it available as well. Okay. I'm just looking to see who's on here. I'm gonna ask, the system displays people's names differently. So I've got on here people within N3I. I've got Emma and Sally, who are both listed as watching it. Can I just ask you guys, are you, hopefully you're seeing the people who get, who want to be admitted. So it still pops up all the time for me in terms of there's someone waiting in the lobby and wants to be admitted. Can I ask you to, if you see that, just to admit people, because once I start the presentation, if someone joins late, it's a faff having to come out of it to admit them again and come back in. Yeah, so if I can ask Sally or Emma, thank you. If you see that, just obviously admit anyone. I do this every time I do these presentations. That there's an option in here that says admit everybody, and I press it every single time, and it never seems to work for me. I just I really need to go back and work out. I'm obviously doing something wrong, because I just wanted to admit anyone to come in. But obviously, once I start the presentation, it's just a bit of faff. I have to come out and do that. Okay. People joining appears to have slowed down a little bit, so I think we'll probably make a start. Let's have a look. So just remind you again that it's being recorded. If you can all stay on mute, that would be great. You don't need to have your webcams on. Actually, a few people have. It's entirely up to you guys. I don't mind either way. Okay, let's get going. Let's get the presentation up anyway. Okay, can someone just confirm that they can see that front slide there, please, for me?
Yeah,
I can
Andrew.
see. Yeah, all done. I can
Lovely.
see.
Thanks, guys. Thank you very much. And I'm getting a little pop-up saying people are in the lobby. I'm sure someone's taking care of that because it's disappeared on my screen now. So thank you very much. Okay. Right, we're a few minutes after 1:30, so we'll make a start. Good morning, everyone. Thank you all for joining me this morning. My name is Barry Jackson, Head of Information Governance at N3I and Data Protection Officer for most of the practices out there. This is an issue that's been going along, access to deceased health records, for some time, certainly since March, April time, when the original notification came through from NHS England that the change was going to be part of the contract of the new GP contract this year. And since then, it's kind of come and gone, and it's been dealt with pretty appallingly, I have to say, I think, by NHS England. So you'll get my personal views on this. Please don't report back. No, do you know what? I'm absolutely fine. You can quote me on anything I say today in respect of I'm your data protection officer, and I think some of this has been done absolutely appallingly. And I've made my position clear on that as well to NHS England in that role. So yeah, you can quote me on what I say. As I said, this is going to be recorded. The webinar, the recording itself, as well as the actual presentation itself, because there's some links in here, will be made available on our IG portal, hopefully this afternoon at some time, as soon as I can get around to getting it all done. So let's get on with this morning. You got any questions? If you can save them to the end, that's fine. If there's anything that's really a burning question and you need to interrupt me, please just shout out. But we've got plenty of time. I don't think the presentation will take more than sort of 20 minutes or so, and a bit of time at the end. We'll go through hopefully all the questions you've got. And obviously, if you all know, if you've got any questions, you want to contact me directly after the presentation, please just do that as well. That'd be great. Okay. Introduction. Oh, and a reminder. Yes. So introduction, I've already said, you know who I am and what this is about. The reminder is that it's coming very soon, guys. It's not going to be deferred anymore. Patient access to their online records will happen on the 1st of November, a couple of weeks away. So I'm doing another webinar. Oh gosh, tomorrow or Thursday, I think. You've all had the invite for it anyway. So just to remind you about it. And there's a couple of links in here, which, as I say, when I put the presentation up on the portal, you'll be able to access those links. There are still events. The first link is to the events page that NHS England are doing, where they're doing webinars every day at the moment, just about. It'd be really useful if you want to attend one of those. And then the actual guidance from NHS Digital, which has all the resources, all the stuff around how to redact information, how to get stuff to not show in the patient record, how you manage the safeguarding aspects of it. All of that is on that NHS Digital page. And as I say, I'll be doing another webinar just to kind of round all that up. But you've really got to be ready for this, guys. 1st November, it is going to happen. And yeah, that's where you'll get more information about it. Okay, so management of deceased records. This is the bit I said that came out around end of March, beginning of April, was this statement. It was contained in a letter to all GPs around the new GP contract, and said there significant change, which is kind of summarised in that in future it will require GP practices to respond to access to health records requests for deceased records, deceased patients' records, but at the same time it removed the requirement for practices to have to print everybody's record and to send copies of that back to PCSE. And then they put in a statement here, which I don't know if you'll agree or not, that it was expected that the savings from not having to print and send the electronic record will far outweigh the burden of managing a smaller number of access to health records requests. Well, yeah. I'm not sure. I suspect long term it will. I mean, I think the absolute nonsense of having to print off these huge electronic records just to stick them in the post to PCSE, to stick them in a warehouse for 10 years. I mean, that was just absolute bonkers and a total waste of everyone's time and effort. Whether I'm not entirely sure that I agree with their assessment that not having to do that, but giving you guys the task of responding to access to health record requests, I think the jury's still out on that one. But that's what it is. So you don't have to print records anymore. Big cheer. However, you have to respond to these requests. And actually, I think once we get heads around it, it's not as complex as it perhaps immediately sounds. the resource side of it will clearly be an issue, and that the complexity of some of the requests are not quite the same as subject access requests in that sense. And the complexity of some of them can be a little bit challenging at first, but I suspect once you get into the swing of things, as with subject access requests, it'll become more of a straightforward task. So, yeah, PCSE's role in this has been absolutely disgraceful. The first, I think, that many of you heard of it, certainly the first I heard of the actual change itself coming into effect, was the email they sent out on the 2nd of August to say that the change had come into effect on the 1st of August. No guidance, no preparation whatsoever. And as you'll recall from seeing that email, it very helpfully told you that you had to comply with the law, and gave anyone else details of how they could complain about the practices if they didn't, details of the ombudsman to complain and stuff. So absolutely disgraceful. However, we are where we are. The change came into effect on the 1st of August, and that's what it is, essentially. So let's have a look. Let's briefly run through the process essentially prior to the 1st of August. I know you all know this. You mark the record as the patient's record as deceased on the clinical system. You used to print out the full record, send it along with any paper record and the Lloyd George envelope back to PCSE. And PCSE are responsible for managing any request to access that record, because they have the full record by both the paper and the printout of the electronic record. So from the 1st of August, the new process, as dictated by PCSE, is that you are now responsible for access to the deceased records. You don't print them out. However, a bit of confusion around this, and I'm still not sure that it's entirely clear, but it does appear that PCSE are saying that you should continue to send the Lloyd George envelope back to them and any paper record that you have stored in the Lloyd George envelope. So that goes back to them. There are ongoing questions and changes, as I understand it, to the Lloyd George envelope itself coming along. As you're aware, it currently has a legal status, and therefore have to be careful about some of the aspects of it. But given that they don't issue them anymore to newborn children, and that for other certain newly registered people aren't getting them anyway, there is a move afoot to discontinue essentially the concept of the Lloyd George envelope. And certainly once we get to full electronic records, if we ever get to that stage, but they will be not required anyway. But at the moment, the guidance appears to say that you still send the Lloyd George envelope and the paper record back to PCSE. That does mean, of course, that if you receive a request for access to a deceased person's record, you can answer it in terms of the information you hold, which will be the electronic record that you've got. However, you still need to tell the requester that potentially PCSE could have an element of paper record. What PCSE are saying is, at this point, you should ask them for the paper record back. They'll send it back to you, and then you can complete the request in terms of giving the information to the person who's asked for it. That seems a bit long-winded to me, but as I said, the purpose of this is to tell you exactly what the current published guidance is around how you do this. There are still some questions, I think, to be answered about this, but this is essentially what it says at the moment. Therefore, my recommendation is you have to follow this, even though I personally may not agree with it, and I'm trying to get it clarified and potentially changed to make it more straightforward. This is what it is at the moment. Okay. And that's where there's a guidance document, which actually isn't the worst thing in the world. My problem with this guidance document here, when you go to it, is that it isn't a document. You'll see it's a web page. There's no details of anyone who's written it. There's no author's details on there. There's no version control. There's no date. It's essentially a web page. And I would assume at this point, a guidance document from NHS England around a legal process, which is what giving access to health records is, should have a more formal look and feel to it. It should be a formal document that we can reference. So I can say, oh, in accordance with this document here, which is officially published by, on this date and version control and so on, this is how it works. It's not, that's just a web page. But as I say, a lot of details are in there, a lot of good information. It's just the way it's published is a bit, I sort of question a little bit. But I have questioned that. That's my point. So that's the process at the moment. Let's get into now a little bit more about the actual access to the record itself. So there's a really important point here about confidentiality. Both the GMC and the NHS and most professional bodies and people who look at this state that the records of deceased individuals should have the same level of confidentiality as if they were living. And what does that really mean? I'll try and give you some sort of examples, probably very simplistic examples, which I sometimes find helps me anyway to understand some of this. If a couple, a married couple came, or an individual comes into your practice and says, "Can I see the record of my spouse?" Husband says, "Can I see the record of my wife?" You say, "No, you can't." Confidentiality, even for between married couples, unless clearly you've got permission and so on. You wouldn't just give it out. So just because someone has died, what this is saying is, and the spouse comes in and says, "Okay, can I see the record of my deceased spouse?" Well, no, there's still a level of confidentiality around it. So you wouldn't just give it out. There are ways in which people can get access to records, and we'll go on to look at them in a moment. But this is kind of a bit of a personal comment, and I think it's borne out by some of the requests that I've dealt with already. Some of the ones that have started to come through. Yeah, that end bit is probably a little bit cynical, but people's judgment can be clouded when we get into claims and wills and things like that. So, but you guys are aware of that anyway. So, just be careful what some people say as we go through this. So what we're talking about here in terms of the law is the Access to Health Records Act, which was published in 1990. Now, it was actually the main way in which anyone got access to any health record from 1990 onwards up to 1998 when the Data Protection Act came in. Now, when the Data Protection Act came in, it applied to all living records and to all living individuals. So it kind of overtook this Access to Health Records Act. However, the Access to Health Records Act was left in place as a statute, but it only applies now to deceased records. So it doesn't apply to records of living individuals because they were superseded when the Data Protection Act came in, which applies to all living individuals. But the Access to Health Records Act, which predated that, stays in place and is what relates to deceased records. And what it does is it gives certain individuals a right of access under the Act. And the individuals who can have a right of access to a deceased person's record are defined as the patient's personal representative and any person who may have a claim arising out of the patient's death. Now, that second one is a huge one, and we'll break it down further. But those are the only two specific individuals or categories of individuals who can have access to a deceased person's record. There is another bit I'll just put on the end here. It doesn't take away organizations that already have a legal duty. So organizations that have a statutory legal duty to carry out certain functions, usually around investigating things such as the police, the coroner, the ombudsman, CQC, and so on, they still have the right of access, which they have actually to a living person's record. So their right of access isn't changed. It's not actually mentioned in the Access to Health Records Act, but it just exists anyway as a legal right that they have because they have a statutory duty to investigate. And that in itself gives them the right of access to a lot of things, including living records and deceased records. So just because they're not specifically mentioned in the Act, it doesn't mean that they're not there. They're not mentioned in the Data Protection Act, for example, but they have a statutory duty anyway. So we don't mention them again, but just so you know that still is the case. We're going to look at those first two categories then of people who can have access to records. So the patient's personal representative is the person essentially who's looking after the will, the executor of the will. Where there is no will, it's a person who has been allocated as the administrator of the will, and that person will hold letters of administration. So if there's no will, probate is granted to someone who becomes the administrator of the will, and they are classed as the patient's personal representative. Now, they can have access to the record, and they can have access to the full record. However, what we need to bear in mind here are there are a couple of caveats to that. And these are fairly fairly complex at first, but actually, I think when you think about them, they're fairly straightforward, and they're what we would expect. Because remember, we can put ourselves into this position here. We're all patients as well, and what would we expect if we were in this situation? So the first one there is, if you're granting access to a record, you should consider the wishes of the patient. So we mentioned earlier on about, a spouse going into coming to the practice. I'd like to see my deceased spouse, husband, wife's record. You've got to remember, so there's still a level of confidentiality around that. And what would the patient expect? Or what would the patient have expressed? What would they have actually said? And many patients coming to end of life will ask something to be written in the record to say, do you know what, I don't want either an individual to know certain things about my health record. I don't want anyone to know certain things that are in there that may be from a long time back. And bearing in mind, our electronic records now, if a patient has been at the same practice, will be fairly comprehensive for a long period of a person's life. And they may say, okay, certain things that have happened that are in my health record, I don't want anyone to see them when I'm deceased. I don't want people to have access to that. And they can put those wishes either formally into the record, or what can sometimes happen is they simply say this to carers or to people who are giving them treatment at a certain time. And so they may have a view on a certain element of the record, and you should certainly take that into account. You still have, which links to that next point, you still have that duty of confidentiality around the record of a deceased individual. You still need to take care as if the person was still alive. There is no difference in terms of a duty of confidentiality. So as the law may have changed, the Data Protection Act no longer applies. There is still this duty of confidentiality we have, certainly as carers, as healthcare providers, and as just individuals. It applies to everybody. We also have to be careful about third-party data and the serious harm test. Now, these two are both things that you'd be familiar with from the Data Protection Act. So third-party data shouldn't be released when you're giving out a deceased person's record. And the serious harm test, obviously, in terms of Data Protection Act, when an individual asks for their record, you're looking at what information would we give them that could potentially cause them serious harm. The serious harm test here around a deceased person is more wider than that. Would it impact on children, for example, or partners? Would there be potentially serious harm done to other people simply by giving them giving out this information? Yeah, I'll move on. I was going to mention that, but I'll mention it further on, I think. So that's the patient's personal representative, i.e. the person who's executing the executor of the will, or doing probate on the will if there's no or doing probate on the estate if there's no will, and we'll have letters of administration. This one is a bit wider and needs to be a bit more careful. So this is any person who may have a claim arising out of the patient's death. Now that's very wide-ranging sort of statement, really. But the important part here is that it isn't the same as the person doing the will. So let's just go through this. So this is for information on a claim against the estate where they believe that there's something in the record to support that claim. So you can grant access to the record. However, it is only for relevant information. And this is really important. So a person who says they have a claim on the estate must say to you essentially what that claim is and what they believe is in the record that would support that claim. And that is the only information that they're allowed to have. Okay. And then the four things that we talked about earlier on: the wishes of the patient as expressed, the duty of confidentiality, third-party data, and the serious harm test. They also still apply as well. But this is, as I say, it's only relevant information that would support the claim that the individual has. Okay, so they're the two categories of individuals who can have access to a person's record when they're deceased. The process for making a request is it must be in writing. You need proof of identity unless you already know the person or it's through a solicitor. So the proof of identity isn't, you know, 2 photo IDs and a letter that shows where you don't need to go to that level. You may want to if you don't know the person. If someone who appears to be almost, say, a total stranger, but someone who you don't know comes in and asks or gives you a letter asking for access to a record, in that situation you would want to see some identity, but the identity level is to assure you of who they are. So for example, if it's a patient, say you have a married couple and it happens to be the spouse that's the executor of the will, and they come in and request to you, if you know them, they've been a patient forever, both both partners were patients at the practice, and it's clear you know exactly who you don't need to go through the identity thing at all. You know who the person is. So it's just to your satisfaction, if you like, in terms of knowing who the requests come from. If you receive a request through a solicitor, you're duty bound to accept that as it is, essentially. So if the solicitor says, I'm acting for this person, and they're making this certainly making this request on their behalf, you take it as a thing that the solicitor will have completed that identity check. The solicitor cannot purport to do something that they haven't done, or be falsely representing someone. They will have done that identity check, and if they say to you, I'm acting on behalf of this individual, you have to take that, and you're familiar with that anyway. That happens in other areas. So yeah, so in writing, and they need to prove to you who they are. And then this is the bit that covers in terms of what the capacity they're acting. So if they're the executor, they must produce a copy of the will, or if they're administrator, then they should have letters of administration. I have to say, I had this discussion with someone the other day, and there are some nuances around this. There are slightly different things that can sometimes, it's not quite as straightforward as I'm probably putting it here. And I have to say, this is all learning for me as well. So what I will build up is, as we go through this a few times, a kind of a body of knowledge, if you like. I'll build up some experience, and so when we do this in the future, we'll do this again. I'll probably be able to give you some better examples of real life things, and say, okay, this is what the sort of thing you may see. At the minute, I haven't got that, but some people have said that you can sometimes get slightly different versions of this. But this is what the law says at the moment, so this is what you should be expecting to see. And if the information is for a claim against the estate, what they believe is in the record that would support that claim. Okay. So what information can you withhold? Well, we've sort of mentioned it already, really. Third-party information doesn't include those involved. So as we do the subject access request, the concept is the same, of course, and you'll be familiar with those. It doesn't involve withholding information around the people who are providing healthcare. You're not classed as third-party information. The expectation is that your details are included in there, but other third-party information can be withheld. Yeah, we covered the serious harm test. Unlikely you would ever get serious physical harm. You're talking about mental health issues here, the sort of information that could harm someone's mental health. As it says, they're the same as the subject access request exemptions. And information that the deceased wished or expected to remain confidential. This is always going to be a difficult call, and I think, well, to some extent, even if they have made that wish, you're going to have to judge or take a judgment on some things that come through. And I expect when you get difficult queries coming through, you're going to need to have a discussion potentially with a colleague or guardian, or with the GP who's involved in care and so on. There are things that can come up here, and as I said earlier, when we're talking about wills and probate and inheritance, and money will cloud people's judgment, so we have to be, that has to be an issue that we think about as well. There is a not famous case, there's a case that's well known, because I discussed it within this area, and I think I discussed it at a meeting with a few people recently, and it relates to insurance claims, where an individual may be diagnosed with a life limiting disease or illness, and they then take out an insurance claim, an insurance which is to pay out when they die, potentially to their partner. And we've had an example. It's because there was a real case of this happened in our area a couple of years ago, and what the deceased person did was, at the end of their life, they made it clear by having it recorded into their record that they didn't want anyone to have access to their record, their medical record. They considered it to be very private and didn't want anyone under any circumstances to have access. That was their expressed wish. Now, when they died, the insurance company were faced with having a payout and were somewhat suspicious around this, around the dates, and they wanted to know from the record the date at which the individual had been diagnosed, so they could compare that to the date at which he'd taken out the insurance, and obviously and the declaration he'd made around his healthcare at that point. And it was held that that information could be released because it was in the public interest. And it goes off here into a slight tangent around the public interest test, which I'm not really going to go into here. In fact, I'm not going to really touch on it at all, other than this in this little tale that I'm telling you. It just says that there are other things that can be sometimes involved here, and in that case, there was a clear intent to commit fraud, and therefore it's in the public interest that that was exposed, if you like, and that the accurate picture was obtained by those people who needed to know about it, and to see what had happened. So there are some things that can, if you go off down these sort of things, if you have suspicions around why things are being said, if something doesn't look right, as in all sort of walks of life, if something doesn't look right and you're concerned about it, and you may get requests like this, then the thing to do is just to contact myself, your colleague or guardian, and to raise this. These are going to be very unusual cases, but there is a process by which we can deal with these situations. But in general terms, you're looking at what the deceased wishes would be and his expectation of confidentiality, which most people have that expectation that their record will remain confidential. As we said, there is no change around that duty of confidentiality. We've got the right to expect that everybody involved in our care maintains the appropriate level of confidentiality, and that continues after we're deceased. Okay, and this wouldn't apply, but it just says any information before November 1991, which is when the Act actually came into force. You can withhold, but actually you probably wouldn't have a whole lot of information around it. Yeah, actually you might. Yeah, I'm just trying to think that through. A deceased person would have had a record going back that far. I think it's not necessary really to worry about that too much. I think if you have that information, you can probably, to make a record complete, you should probably give it. But it's just because that's the technicality around the Act only came into force in November 91, so it can only apply from there forward. It's not a retrospective Act. So any information that's before 1991, unless, as it says here, it's necessary to clarify something that is subsequently in the record as well. So if you have the sort of history of an episode of care that started before 1991, you may need to include it, so the next bit makes sense, if you like. I wouldn't get too concerned about that bit, I don't think. Right, I'm not going to read through all of this. As I say, it will be in the presentation, and you guys can look at it. This is from the BMA site, and it's this issue about when someone has died, what immediately information would you give to the nearest, to their family who may have been maybe sat there? It depends. Obviously, it depends very much on the way in which someone has died and the circumstances. However, what it's saying, I think, is that it would be, I can't remember the actual term it uses here. Disclosure would be what the person would have wanted, and refusal would be a bit, it wouldn't seem right. So this is telling the immediate family essentially what's happened as someone has passed away. And I think it's certainly what it's saying is, you don't want to just be saying, no, okay, that's all now under the Access to Health Records Act. You'll have to put an application in writing. We'll have to check your identity. Nobody wants to get that at the point at which someone has pretty much just passed away. So have a read of that, and I think it's fairly self-explanatory, really. And the bit I've added on the bottom is we've got the new concept of medical examiners coming in, and it's specifically in their role that they may be involved in doing this bit. So they're the ones who will be looking at the immediate aftermath of an individual's who's passed away. The medical examiner will be involved, and they may be the ones who are speaking immediately to the family and potentially passing on details. But that would be done not under the Access to Health Records Act. This is the sort of the immediate bit, which isn't really covered essentially by legislation, and they're saying it probably doesn't need to be. It's an example where the law it's kind of would be almost too difficult to write, and it's very much based around people's common sense judgment. Okay, yeah, the fun bit, can I charge a fee? No. How long do I have to respond? 21 days if there's been nothing recently in the entry in the record, or 40 days if there's been a recent entry to give you time to kind of review it and to go through it. So 40 days from the last entry, or 21 days if it's if there's no recent entries in it. Okay, I'm happy to take any questions now. I hope that's been useful and interesting. As I say, this is all, or an awful lot, this is new to me as well, and I think certainly already from the questions and the queries I've had, which I'm absolutely delighted to get. You know, my whole point here is, you know, keep me busy by asking me lots of questions. That will help me build up a knowledge of the way these things work. And I say we've all got that around subject access requests. We've been doing them for years. We all know how it works and so on. This is new. We're going to need to build up that level of knowledge. So please, when you get some of these questions, if you're unsure, or even if you are sure, just, you know, it's really helpful to build up my knowledge around this just from people's experience, and then we can pass that on, and we can build up examples and you know, case studies and stuff like that, which will help us all as we go forward with this, bearing in mind that it's still all kind of fairly new. So let me just stop sharing that and ask if anyone's got any questions they'd like to ask now, or you could put in the chat if you want to write them down to the chat forum there.
Sorry, Barry, I've got my hand up. It's Michelle.
Yeah, Michelle, hi.
Hi. Yeah, I was just querying one of my concerns raised is some of the people that might want access, we won't know them. They might not be patients, but they might meet the criteria. But what if those patients have got like a mental health illness that it wouldn't be in their best interest to share that information? You know, like we do now sometimes with patients, because they've got maybe a delusional illness and it's not in their best interest to have their notes. We might give them a copy, and it might obviously aggravate their condition already. How do we go down there? Because we won't know that patient.
No, that's a good question, Michelle. So I'm thinking, so that falls within the serious harm test, but when you're doing a subject access request, you know the person that you're giving it to, therefore you can make that judgment. Would this information cause this person serious harm? With this one, you could potentially have a request from someone that you don't know, and therefore the information in the record could potentially cause that person serious harm, but you can't make that judgment call because you don't know him. I suspect in that case, then we've got the concept of the serious harm test has to be broader, and you just have to say, would it cause any person serious harm? And if it would, then you can redact that information. And I do think, to some extent, as with subject access requests, I would urge you to be not overly cautious. We don't want to get sort of, you know, I don't know, ridiculous, but we don't want to go too far down this line. But I think if you're into mental health areas, then you can quite legitimately be fairly cautious about holding information back, and you'd be quite within your rights to do that. You say, well, if you had any sense that it was going to cause that level of harm to an individual, then I think you'd just say, okay, we'll just hold this bit back. And if you're challenged later on, you say, well, that was my judgment. You can't be overly criticised for that. So I think you can slightly err on the side of caution there if you do have concerns around giving information out to someone who say you don't know.
Yeah, but that's it. We wouldn't know until after, you know, obviously until somebody said, well, what you've given has caused them to be because we have issues. We have a couple of patients now where they request access, but we've refused it. It's not. We don't think it's in their best interest to share any access because they've got a fixation with health.
Sure.
So we don't share any information. So
yeah,
um,
that's fine. And I think,
but I don't know if you don't know the patient, the impacts that if you shared that information, the impact it would have on, because you wouldn't know, would you, until afterwards, really?
no, that's right. So I guess going back to the two categories, would that person be the person who was administering the will potentially, or would they be someone with a claim? It's unlikely they'd be perhaps someone with a claim on the estate. I just think, yeah, as you said, Michelle, I think you can be probably slightly more cautious around this. If there is information in there that you think is going to cause serious harm to any person, which is the test, not just subject access request where it's to that person, it's to any person. Therefore, you would withhold that information. So the sensitivity of the information that you have is the test, and you think, well, hang on, anyone here in this could potentially be harmed by it. Therefore, we'll withhold that information. And I think that's a call that you wouldn't get overly criticized. Well, you wouldn't be criticized for at all, I don't think. If you're challenged on it, if that's your belief, then that's your belief, and that someone else may come in at a higher level, and if you get challenged, someone may want to review the decision, but that's that then takes it out of your hands anyway. But I think if your decision is, I'm concerned here, and I think this may potentially damage, cause serious harm to someone, then you just make the decision to withhold it, and that's absolutely fine. The law, the provision is in there exactly for that purpose. A couple of questions in the chat. Let me just quickly go back here. PCSE, yeah, okay. I think we all have our views on PCSE. You're absolutely right. In terms of the deadlines, I'm going to ask for clarity around this because it isn't particularly clear. I would think that essentially the clock stops, if you like, when you send the request to PCSE. So if we're talking about 21 days because you receive a request for a record from a few years ago where there haven't been any recent entries to it, if you send that, you might take a couple of days to process it yourselves, send it to PCSE. You've had it for, let's say, 3 days. Your clock stops at that point, and it doesn't start again until you get the information back from PCSE. That would be my view on how it works. I think the similar concept works around Freedom of Information Act, where if you ask someone for information outside your kind of remit, you have no control over how long it's going to take them to get the information back to you, then the clock stops from your perspective, even though you've got the legal duty to provide that information within a certain time. If you've got no control over that external bit, then that's how it works until you get it back, and then the clock starts again for you, and you've got however many days then to give that information out. But that's something which I will pick up. That's a good question, and I'll pick up and clarify that. Yeah, how do you come up with patient's wishes when the patient doesn't have capacity? Yeah, Alice, that difficult question. I think all these ones around mental health and mental capacity are always complex. I think you almost have to go back to some of the straightforward concept. Acting in the patient's best interest, the duty of confidentiality, these kind of bigger things. Because I suspect when you start trying to put things like that into the law isn't written for all of these different eventualities that you guys have got. You guys are dealing with hundreds of different types of scenarios, and the law is a kind of very simplistic thing. The access to health records is about 10 pages long, very kind of high level and simplistic. You need to look at things like, I say, the duty of confidentiality, and I would also say err on the side of caution. If you don't think you should give information out, if that question is even coming up, usually, okay, that's probably not the right thing to do. Then if you are even having that question, should we do this, chances are it's probably not the right thing to do, and therefore go around again the patient's best interests. What would the patient want? What are their wishes? You can. The interesting bit about the patient's wishes, and we had a case recently, just last week, I was talking about one where it may be that the patients would have wanted the information to come out, and this is related to a claim that someone had to cancel a holiday because grandmother had died suddenly, and they're making a claim to get their money back, essentially. And it wasn't necessarily directly on the estate. But when we kind of talked it through, we said it was absolutely clear that what the grandmother would have wanted, she would have wanted the information to be released, because she would have wanted the family to have been able to make their claim, because they couldn't go on holiday because of her death, if that makes sense. So sometimes it's not just the patient saying, no, I don't want the information to be released. It's that what would the patient have wanted in this scenario? Actually, they would have wanted it to be released. So it can work both ways at times. Let's have another look. Yeah, Andrew's point about mental health. I haven't worked in mental health. I have no experience of that. I've spoken to some people who do. I understand some of the many issues that you're going to have. Yeah, the serious harm thing has to come into that, and the scenario that you're facing. And just, trust your judgment, guys. And I know that you've got such a wealth of experience there from dealing with this, the sensitivities that you deal with, the confidentiality. You know all this stuff. I'm not telling you stuff you don't know here around, patients' wishes and so on. Trust your good judgment about it. But also talk to the people as well. Talk to me, talk to your colleague or guardians and practices, talk to your colleagues. You're not on your own. You're not trying to make a decision. If you're absolutely stuck, there are plenty of people you can, just try and anonymize the little scenario and the issues that you've got, and ask for help. That's absolutely fine. Certainly what I'm here for. If you think I can help with any of this stuff, just come to me. What we got on? Do legal terms trump the patient's wishes? What if the patient say they didn't want X person to access the access? Oh, that's a fantastic question. You're right. You have two diametrically opposed situations here. One is that the law is saying this person here can have access to the record, and at the same time you're required to take into account the patient's wishes, and the patient said, I didn't want this person to have access to my record. On that scenario, I would say you go with the wishes of the patient, and confidentiality, because that's actually going to almost take it up to the next level. If someone wants to challenge that, then it will be challenged possibly in a court or wherever, but it almost takes the decision up to the next step and let someone else. I don't mean just to pass it on there for the sake of getting out of it, but I do think there's a complex interaction between the law saying one thing and you saying the other. I think it's quite right almost to pass it on and say, you know what, let someone else deal with this. My duty is to the patients, and in your view, the patient wishes are paramount. If the patient said, I don't want this person, I mean, it could be my partner, I don't want my partner ever to see my record, then, and subsequently the patient dies and it turns out that their partner is the one who's administering the will, then in that scenario, I would say, no, I wouldn't allow them, irrespective of the fact that the law says they can. The patient's wishes, from my perspective, would override that. Now, if the administrator then wants to take it to the next level and challenge that, then fine, that goes up and let someone higher up, a lawyer or the court themselves would have to make that decision. But I think that I'm very much around the patient's wishes. If the patient has expressed the wish that either the whole record or a part of their record or an individual shouldn't have access to it, then I think that's at the level we're operating at, that's what we go with. But these are all judgment calls. But I'm giving you my sort of thoughts on that. I think what you would do, Alice, I would suggest at that point is certainly ask, if you're dealing with that query, ask someone else for a bit of help or advice, whether that be me, whether that be a colleague or guardian in your practice, the GP who was the patient's named doctor or something like that, and just talk it through with someone else. Specifically, so I said you want to enter the nurse should have been considered time back to make a decision. Yeah, Angela, mental capacity is it's something you guys deal with. I'm sure all the time. If someone says to to a healthcare professional who's dealing with them that this is my expressed wish, you should record. I'd say you should record it, but you can put in your additional views. That does the person have the capacity at the time to make that? I think one of the common themes that comes through this, and we've seen a couple already come through, are where people who had an expectation that they would be in someone's will and that they would be going to be left an inheritance, find that they're not, because in the later stages of their life, the individual changed their will. And that's where you often get into questions around the mental capacity of the person at that stage to have changed their will. And therefore, yes, people who are writing things in should hopefully have said this is the patient's wish, but also their mental capacity should be recorded as well. I'm not exactly sure how that happens, or whether that happens as kind of as straightforward as that. But yeah, I would hope that that's the case, that if someone's writing about mental capacity, and certainly something as significant as excluding someone from records and so on, that the healthcare professional would make a note about the capacity of the patient at the time as well. Okay, it's a fascinating subject, and I'm sure we'll have more on it. As I say, I'd love if you guys, as you're getting these requests now, if you feel you're able to share some of that with me. I'm not to check your homework or anything like that, but really just so that it'll help me build up my own knowledge, and within our community we'll have a better understanding of these things and the way that people think about them. We can have discussions clearly with anonymized sort of case studies. We can talk them through, and it's always better to get that real, here's a real case, this actually happened, what happened in this scenario, and I think we'll all learn from doing that sort of stuff. So if you get a request for a sister or a patient that passed away before the 1st of August, are we right in directing this? No, okay, Matthew, I'm going to agree with you that you should. However, you can't. The view from NHS England, as expressed through PCSE, is that you have to deal with all requests from now, and that's irrespective of the date. So any request that comes in, even if the patient passed away before the 1st of August, you are now responsible for dealing with it. However, it's clear that the first thing you're going to have to do if the patient passed away before the 1st of August, is you're going to need to ask PCSE for the record, because they still hold it. So you need to ask them to give it back to you. Now, I think that's a bit of a nonsense. Why? You should just direct them directly to PCSE anyway, and they should do the request as they do now. But as I say, they have changed the process, and the process is now that you have to deal with all requests, even though if it's before the 1st of August, you're asking PCSE to give you the record back to you to then fulfill the request that you've received. Michelle, did you have something else?
Yeah, I was just going to say, so obviously I don't know the rationale of why it's changed, but I'm assuming the PCSE got paid to do this service on behalf of the NHS. So are we now getting that funding?
I think, well, I know that questions like that have been asked through the LMC and various others. I'm not in a position to be able to say how the funding's worked out from that. I think there is an element of, you have saved some money by not having to print out records. And I'm not, as I say, I'm not going down the route of trying to say there's an equivalence here. What they have said is you don't have to print out records. I don't know. The one thing I don't know actually is the volume of requests. And actually that statement at the beginning that was made by NHS England around, they think it'll be, you'll benefit from not having to print out records and only having a small number of requests that you have to deal with. I'm not sure how. I think we need to let this run for a while until we see if that's actually the case. I don't know in terms of the general run of the mill how many requests you get, or how many you will get once this kind of settles down and they are coming through to you. Whether that's one a week, one every 2 weeks, 2 or 3 a day, I don't know. You'll then be able to make the judgment of whether that's a significant resource to you compared to having to print out hundreds of pages for every person who died. I think, yeah, I just think we're not quite in a position to be able to make that judgment yet. But in terms of where the money went, I'm sorry, I don't know. Okay. If there's no more questions, I can't see any more hands up at the moment. Thank you all very much for listening this morning, for coming along. I know you're incredibly busy. I'll get this. There's a couple of technical things I have to do on the recording, and then I'll get it put up onto the website. I'll put the presentation up as well, as I said, that will have those links to the guidance documents, and to the stuff around patient online access. Don't forget about that. And I've got another presentation tomorrow, I think, or Wednesday. And I'll hopefully see you all then. Thank you very much, everyone. Thanks.
Thanks, Barry.
Thank you.
Thank you.